Hello. Nice to meet you. I'm Matt Margolis. Chances are, if you're watching this, this is the first time you are seeing me or interacting with me, even though we're not really interacting. But I'm glad that you're watching this video, probably in lieu of an initial meeting. Um, and really, the goal of this is to provide all the same information that we would provide if you would come to my office, or if we scheduled a Zoom that was one-on-one. Um, all the information I'll cover during the next 30 to 40 minutes will be identical to if we sat down and we met face to face, or if we met over Zoom. It's the exact same information. I give a lot of talks to the public on the same topic, sort of like I kind of refer to it as like estate planning 101. Again, it's sort of all structured in a way that I try to make things very easy for people to understand. A lot of the time, it's people's majority of the time, it's people's first time having any kind of getting any kind of information related to estate planning. So I hope you learned something and enjoy. So when we look at planning and we look at estate planning in general, there's sort of two main paths that we can go down. So I'd say the path that I think a lot of people are more familiar with would be the idea of a will, and it's probably just because it's one of those documents that we've heard people discuss over time. Maybe you heard your grandmother talk about her will, or your grandfather, or your parents, and sometimes even when people have trusts in place, which we'll talk about in a second, people still refer to them as wills because it's more of that household term. Then we look at the idea of a trust, and I think a trust, for some people that aren't familiar with them, they kind of have this idea that trusts are just for wealthy people, right? They're just for people with a lot of money, and that's probably because we've seen it in movies or TV shows, or we went to high school or college with a trust fund kid. And yeah, one of the things that we'll discuss today is that people with a lot of money can benefit from trusts. We could use them to avoid estate taxes. We'll touch on that very briefly. But the reality is that the majority of people that we meet with in our office, and I'm going to argue the majority of people in general that create trusts, are not doing so because they have tons of money. They're typically doing so to avoid probate, which we'll get to. So when we look at planning, again, we look at the idea of a will and a trust, and I'll pick on myself because it's always easier for me to do that. And frankly, I don't know who you are, so I can't pick on you anyway. So if we take my situation, and let's pretend that my wife and I never did any planning. And so we know that we look a lot like a lot of you, right? We've got some version of, having checking accounts, savings accounts, brokerage accounts, IRAs, 401ks, life insurance policies. We might own a house or a condo. Maybe we're fortunate enough to own a second property somewhere. And we've got all this stuff. And the question becomes, and the reason why you're potentially interested in meeting with me is, where does all this stuff go when we die? And not just where does it go, because we might have an idea of that, but how does it get to the people or to the places that we want our stuff to go to? And so ultimately, for married couples, we sort of have this built-in estate plan without really knowing about it. And that's because, we'll look at my wife and I again. Before we did our planning, we owned most of our stuff jointly, right? We had joint checking accounts and savings accounts, brokerage accounts. The house was in both of our names. And then when it came to all the accounts that we did not own together, like life insurance policies and 401ks and IRAs, while those weren't owned jointly, we were beneficiaries for one another. So the reality is, if something had happened to me, everything would have gone to my wife strictly based on joint ownership and beneficiary designation. And vice versa, right? If something happened to my wife, the same thing would have happened. Everything would have gone to me. So a lot of married couples can kind of get away with doing no planning up until the time that first spouse dies. Now, of course, I'm not suggesting that any of you married couples that are watching this wait until the first person passes away to do any kind of planning. I'm just saying that sometimes married couples can get lucky, where there's really not a huge administrative mess when the first spouse dies. Obviously, in the same example, after my passing, if everything's in my wife's name only, this is where we typically have the issue, right? This is where we find that there can be problems or more administrative challenges when a single or widowed individual passes away. Why? Because now everything's in my wife's name only. the checking accounts, the savings accounts, the brokerage accounts, the real estate. And even though we've got 2 kids, all that stuff's in my wife's name joint only, sorry. And then, of course, with the IRAs and 401ks and life insurance policies, she might have the kids named as contingent beneficiaries. But if they're minors at the time and something were to happen to my wife, would we want our kids having access to the money? And not just that, but even if they weren't minors, what if they were in their early 20s? What if they were in their late 20s, but just really not responsible kids? Maybe still a failure to launch for them. Maybe we've got children that have some sort of addiction or some sort of illness or special needs. We don't want the money to go directly to them. So there's other considerations and other planning tools that we might benefit from to make sure that we leave everything to our kids or in your case, whoever your beneficiaries are, but we do it in a smart way. And so in one example, my wife could have a will, right? And if she has a will in place, a will is really the way I would describe it is sort of like a letter to the judge. Okay, because if I pass away or if my wife passes away in this example and she has, again, some brokerage accounts, bank accounts, real estate, and then she's got some IRAs and life insurance policies, any assets that are in her name only that don't have a beneficiary on them are going to get to the beneficiaries that she's designated in the will, but they're going to have to go through probate first. And probate is a court process where ultimately the judge looks at my wife's will and determines where all of her stuff should go based on the language in it. And not just where it's going to go, but who's in charge, right? Who's going to manage this probate process? Many of you have maybe heard the term executor before, right? The executor is the person that my wife would name who would manage the estate, who would hire a lawyer, who would deal with the estate in the probate process in court, making sure that at the end of the day, everything gets to the beneficiaries in the manner that she wants the beneficiaries to get them. I say we because most married couples, if they do create wills, likely their wills are going to mirror one another. It'd be pretty uncommon for those wills not to say the same thing. And here's the thing, right? I just want to really hammer this point home. A will does not avoid this probate process. A will does not avoid this court process. And a lot of people think that it does, okay? Now, any accounts that my wife has beneficiaries on, IRAs, 401ks, life insurance policies, etc., those will avoid probate. And the beneficiary designations will supersede any language in her will, okay? The assets that will go through probate, that will go through this court process, and then will be subject to the terms of the will, would be all those assets that are in her name only. And in a lot of cases, that's going to be real estate, checking accounts, savings accounts, brokerage accounts. We've seen situations where an individual's passed away and they didn't have a beneficiary named on their IRA or on their 401k or on their life insurance policy. Maybe they had a spouse named, but they never had, and their spouse predeceased them and they never had any contingent beneficiaries. They never named their adult children. To me, there's no excuse for that, but these things happen. So, if you walk away with one thing, it's check those beneficiary designations. Make sure that, you don't just have your spouse listed. If you're married, you've got your children listed as contingent beneficiaries, or if you're not married, you don't have children, you've got somebody, and you don't just have a primary beneficiary, but you've got contingent beneficiaries, right? Because that primary beneficiary is not always going to survive us, unfortunately. So again, the will is a great document. It will ensure that what we have will go to the people we want it to go to, but it will go through probate. And in most cases, the assets will go through probate with a will. Now again, probate's not the end of the day, or end of the world, sorry. I would argue most people, when presented with the option of avoiding probate, and I've been doing this for 12 years now, so I can tell you that most people would prefer to avoid probate. But at the end of the day, probate is going to probably take, Cook and Lake County, where we have most of our clients, you're probably looking at about a 12 to 18 month process. Could be longer. We've got estates that we've worked on that are over 2, 3, 4 years, where there's just, people aren't getting along. They're a lot more complicated. There's obviously other factors. I mean, probate can be like divorce. There are very simple, more straightforward probates, again, sort of in that 12 to 18 month range. And there's more complicated probates, where, again, people aren't getting along. It's a little bit messy. People are fighting. And it could be 2, 3, 4, 5 years and cost a lot of money. I'd say the average probate probably not going to be less than about $4,000, $5,000. I'd say probably most of them are in that $4,500 to $10,000, $12,000 range. It is what it is. Okay, right? That's sort of what we see in probate. And again, not the end of the world. Just want to make sure people understand sort of what it means to go through probate. Okay. So you're probably thinking, how do we avoid probate, right? How do we avoid this probate process, this court process when somebody passes away? And the reality is that in most cases, the way that we avoid probate is through the use of a trust. And the type of trust that we're going to talk about today, because there's various types of trusts out there, we're not going to get into all of them. The only trust that we're going to talk about is the revocable living trust. Okay. And the revocable living trust is the most common type of trust out there. I would argue that if you have a family member or a friend or a coworker that's mentioned that they've done their estate planning or they have a trust in place, probably 95% chance, maybe even 99% chance that what they have is a revocable living trust. Just a very common planning technique these days. And for most people, we're going to use this document to avoid probate. They're not going to be using this as a mechanism because they have tons and tons of money. But we'll get to that piece as well. So let's say that my wife and I create a joint trust. Okay. So we create the Margolis trust. And we would be called the trust makers. All right. It's exactly what it sounds like. We're making the trust. We get to decide what the terms of the trust are. You know, who's going to get things when we pass away, who's going to be in control if we can't be in control because we're incapacitated or we pass away. Where does everything go? How does it go to them? And we get to decide all of that. It's also going to be our stuff that goes in the trust. For a trust to avoid probate, it's not good enough for clients of ours to leave the office and just do nothing. Okay. Now, people should feel really good after they do their estate planning. Most people do. For a lot of people, you know, it might have been something that they've been thinking about doing for 10, 20, 30, 40 plus years. So you should definitely feel a sense of accomplishment for getting your estate planning done. But when we have a trust in place, we're not done. We're like 85% of the way there. All right. Now that we have the trust in place, we need to retitle our assets. This is how we avoid probate. And when it comes to IRAs and 401ks and life insurance policies, those don't go into a trust. An IRA or a 401k cannot be retitled to a trust. With a life insurance policy, if it's a whole life policy, we can retitle it to the trust. I'm typically not as concerned about doing that as we are about maybe adding the trust as either a primary beneficiary or maybe a contingent beneficiary of the life insurance policy. And in some cases, we might even name the trust as a beneficiary of an IRA or 401k. Again, I'm not going to really get into that too much during this talk. We kind of discuss those things on a case-by-case basis. So clients leave the office, what's next, right? I mean, so we'll present, we'll give them a lot of guidance as to what they need to do, right? We're going to go through every single account they have, all their IRAs and 401ks and brokerage accounts and checking and savings and yada, yada, yada. Number one, you know, we and most estate planning attorneys will do this, you know, we'll help them retitle any real estate they own to the trust. So they've got, you know, or if you have a house or a condo here in Illinois, we'll retitle it to the trust. Let's say you own a property in Wisconsin or Florida or California. While we won't specifically do that, we'll typically bring on an attorney who practices in that state, and we'll have them help us out and make sure that they put a deed together that would transfer your property in that other state into your trust. And we can put it into the same trust we're creating. We're not creating a separate trust for that property. When it comes to the bank accounts, whether we are advising that certain accounts get retitled to the trust or certain accounts be updated where their beneficiaries name the trust, where we name the trust as beneficiary, we don't physically do that for you. Most law firms don't. There are some that do, okay? But it's more common that the clients would do that. And so what we'll do is we'll go through all of your assets and make sure that you know exactly what you need to do with all of them, right? You need to go to Bank of America and retitle the checking and savings accounts to the trust. You need to go to your financial advisor at UBS and retitle your brokerage account to the trust. You need to update the beneficiary of your IRA and 401k to your spouse first. And your trust is contingent because you've got minor children and we don't want those minor children having access to the distributions, to the required minimum distributions of that IRA if something were to happen and they were still young. So again, great to get a trust in place, but we really need to make sure that we're funding the trust, right? This is what we call funding the trust, when we're retitling assets to the trust, when we're updating beneficiaries to the trust. And that's really the last step, okay? So don't mean to beat a dead horse with that, but I can tell you that people will put trusts in place, and we've seen clients where they come to us, they did planning with another attorney 10, 15, 20 years ago, they come to us and there's no assets in their trust, right? They have a trust that's empty, it's got nothing in it. If something were to happen to them tomorrow, they would actually still go through probate, and we'll talk about what we do in that situation when somebody has a trust. So my wife and I are the trust makers, right? Back to that. We're the ones creating the trust. We can make changes to the trust. A revocable trust can be amended as long as we have capacity, right? We lose capacity, we don't have the ability to make changes to our trust anymore, okay? And the trust becomes irrevocable. My wife and I would also become the trustees or be co-trustees of the trust. And as trustees, we can deal with all the assets that the trust owns. Just like we were joint on the accounts before, and we could do whatever we want. We could write checks, we could deal with our financial advisor, we could make decisions, we had carte blanche to do whatever we wanted. Now that things are in the trust, it's not like we're restricted. We can still do all of that. We're co-trustees. We both have access to everything, okay? We don't lose any access just because we created a trust. The trust operates off our social security number. I tell clients all the time, when you put a trust in place, literally your lives do not change. You file your taxes the same way. As far as the IRS is concerned, you don't even have a trust. The only difference you're going to notice is that on my bank statement, rather than it saying, Matt Margolis, and then my address, it's going to say the Margolis Trust, Matt Margolis Trustee, and then my address, okay? It's the biggest change you're going to see. Now, we need successor trustees because at some point, neither my wife nor I will be able to manage the trust. And we know that because at some point we'll both pass away. Prior to that, I could pass away, my wife could be alive but incapacitated. And so we need somebody that can step in and manage the assets in the trust, either for one or both of our benefit, if at least one of us is alive but incapacitated, or to step in and manage the estate, to manage the trust estate, to make sure bills are paid, real estate sold, etc., and then money is distributed to the beneficiaries after we pass away. A lot of times, you kind of look at the idea of a trustee of a trust is very similar to an executor of a will, right? Who's going to step in and manage things? But again, in this case, it's not just when we die, where a will only kicks in at death. The will does nothing for us during our lifetime, where a trust is a living, breathing document from the day we sign. And so that successor trustee can step in, again, while one of us is alive but incapacitated. We can name as many successor trustees as we want. We can name them one at a time. We can name them, two of them, two together to act as co-trustees. It's very much like with an executor of a will, which I didn't really go into that much detail, but with an executor of a will, we can name co-executors, or we can name executors to act one at a time. I can name 5 people in order. I can name 2 people, okay? Sometimes we've got more people than others. Got some clients, it's a struggle to name 1 or 2 people. Some clients, they've got 5 or 6 people that they really know, like, and trust that they can name and put into these positions of authority, right? So we've got successor trustees of the trust. And then at the end of the day, where does our stuff go when we pass away, right? Who are the beneficiaries? For better or worse, clients that have children, for those of us that have children, it's sort of easier to think about who our beneficiaries are, because most people that have kids are sort of like, well, when we pass away, it's going to go to our kids. And they might leave a small percentage to charity. But again, I've been doing this for 12 years. The vast majority of people that have kids are going to leave it to their kids. But again, obviously you can leave money to your children, your nieces, your nephews, your friends, your mom, your dad, charities. There's plenty of different ways to divide an estate up. When we leave money to individuals, there's sort of 2 different ways we can leave it to them. We can leave it to them outright. An outright distribution would be, an example that would be, let's say my wife and I have $1 million estate at the time we pass away. After all taxes and expenses are paid, there's $1 million left. Well, our trustee, and let's just say that's my brother steps in as trustee, and he takes that $1 million and he writes a check to each one of our kids for $500,000 because they're each a 50% beneficiary, and that's it. They get the money and they can do whatever they want with it. It's theirs. Okay, that's an outright bequest. But for those of us that have minor children, my wife and I have minor children, and some of you might have minor children, and maybe they're not minor children, maybe they're just not necessarily that responsible yet, or you don't want to leave them a certain amount of money if something happened to you tomorrow. Then in some cases, what we'll do is we'll leave our beneficiaries' money in trust. And this isn't a separate trust that we're drafting. This is, the Margolis trust for the benefit of our son, and then the Margolis trust for the benefit of our daughter. Okay, it's like these two little trusts spring out of our trust. And in this kind of using the same example I just mentioned, my brother as trustee would step in. Each of these trusts would be created. $500,000 would go into each one. And the way that we have it set up is that our kids, if they're under the age of 30, when the second one of us passes away, the money would go to them in trust. And my brother as trustee would manage it for their benefit. And he could use it for their health care, their education, and really their sort of general maintenance and support. What does that mean? It kind of gives him a lot of discretion. I kind of say, look at that trustee as like a surrogate parent to your children or your beneficiaries from a financial standpoint only, right? Our kids they need money for something. They're going to go to Uncle Mike, the trustee, and ask him for money, and he's going to get to say yes or no, right? And the idea is that we're typically naming trustees, especially when leaving money to minor children. It's different, obviously, if we're leaving money to other people, but if we're leaving money for our children, we typically are looking to name a trustee that has similar values to us, because we want to make sure that, God forbid this happens, our trustee is going to manage the money and treat our children as if as similar to how we would treat them if we were still alive. In a perfect world, our kids are over the age of 30 when the second of us passes away, and then it becomes an outright distribution. The money will not go into trust first, right? They'll just each get their check and they can do whatever they want with it. So we kind of set things up like this as a protection, right? A protection against themselves. Because listen, even though everybody, we're all technically adults at age 18, I don't think I've had one client that I've worked with in 12 years that's been like, you know what, when my kids are 18, they can have the money and do whatever they want with it. I don't think that's ever happened. We also have to consider that our beneficiaries may not survive us, right? And I won't go into all that detail now, right? Everybody's situation is a little bit different, but what if one of my children didn't survive my wife and I? We can plan for that now. And it was, I don't think my wife appreciated when she was 3 months postpartum and when we were putting our estate plan together. And I was asking her, well, what if our son passed away? Where would his share go, right? And of course, that was probably not the right question to ask her at the time, but I sort of answered it for her. And I said, well, we got to look at this 40 years in the future. If he had kids, we probably wanted to go to his kids. And we can kind of build those contingency plans in now. We don't want to think about these things, but unfortunately, this is why we plan, right? We plan. I always tell clients, we're going to plan for the worst and hope for the best. But I'm going to want to plan for the worst. Unfortunately, we're going to have to talk about some things that are going to make you uncomfortable. And it's not because I want to, it's because I want to make sure that you're protected. That's what I'm here for. If I just beat around the bush and we don't cover certain things just because I don't want to hurt your feelings, that doesn't help you out, right? So we have to have those difficult conversations. And again, just because we're planning for something, obviously it's something we want it to happen, right? But we can kind of build those contingency plans in place. Well, if one of my kids didn't survive us, it would go to his or her children if they had children. If he or she didn't have children, then it would go to our surviving child. What if something happened to my wife and I and our 2 kids? We were on a bus and the bus fell off a cliff. We didn't have any grandchildren. Where does everything go in that example, right? So we even get to that point with clients. I refer to this as the Armageddon clause. In the trust, it's actually called the remote contingent distribution. But to me, it's the Armageddon clause. If Armageddon happened to my family only, right? Or your family, where does it go? Does it go to nieces and nephews, your brothers and sisters, your parents? Is this where we all of a sudden get charitably inclined and we want to leave it to charity? So I even want to plan to that level. So I know that was a lot. So, if you were sitting with me, I'd ask you if you have any questions, but unfortunately, we can't do that. That's really how a trust works, okay? It doesn't have to be complicated. Some situations are obviously going to be more complicated than others, but in some of these situations, it might be fairly straightforward. Now, I want to, before I step back for a second, I referred to this idea 5-10 minutes ago about the idea that even with a trust, we can go through probate, right? Because I mentioned that there's some people that will put a trust together and the attorney will provide guidance about retitling their assets into the trust. Or you might have attorneys out there that are not providing you that guidance, and it's not the client's fault. They just had no idea that they had to go to their bank and retitle their bank accounts. And so what happens is we have situations where people pass away, they have a trust in place, but they didn't retitle certain assets into the trust. And maybe it's because they bought a second house 20 years later and they just weren't thinking about their trust. Or again, the attorney didn't provide any guidance to them about retitling assets to their trust. So if at the time I pass away, right, let's say my wife predeceased me, at the time I pass away, if I have assets in my name only that do not have beneficiaries on them and that are not owned jointly with somebody else, and that again are not in the trust, that can go through probate, even with a trust in place. And so every time we have a trust, every time we put a trust together, we always create what's called a pour over will. A pour over will, kind of like a pour over coffee. And really the pour over will is going to really have three main aspects to it. Well, if you've got minor children, there'll be three main aspects. If you don't have any minor children, really two main aspects to it. So for those of us that have minor children, the will is where we name guardians, right? Who's going to take care of our kids if something happens to my wife and I before our youngest turns 18? You know, we can name couples that can act together. We can name individuals just by themselves. And again, similar to naming trustees of the trust, executors of the will, we can name as many as we want. And again, we're either going to name them as a single person or as a couple, a married couple. So we name guardians in the will. We name executors in the will, right? We already discussed that, right? We talked about a will in the beginning, so we name executors. And anytime we're doing a will with a trust, okay, the pour over will with the trust, typically the executors are going to mimic and are going to match the trustees that we named in the trust. Okay, it just makes sense because if something slips through the cracks and goes through probate, I want the executor of the probate estate in court to be the same person as the trustee of the trust so that that person's just handling everything. Okay, I don't want it to be two different people that have to, coordinate and get on the same page about something. And then the last thing is the pour over provision. Okay, so the pour over provision of my will basically says, hey, judge, if you're reading this, two things happen, right? I have a trust in place. Well, first, three things happen, right? I passed away. I have a trust in place and something slipped through the cracks, right? Something did not make its way into the trust. So after this probate process, I want this asset that's going through probate, whether it's a bank account, whether it's a piece of real estate, I want it to pour over into the Margolis trust. And that's kind of why we call it a pour over will, okay? So it's a really simple will that really just names my trust as the beneficiary. So every time we create a trust, we always have a will that goes with it. I hope we never use that will. Okay, I kind of refer to it as a safety net. Hope we never use it, right? Obviously, we hope our trusts are fully funded. And in the case of those of us with minor children, I obviously hope that you and I survive our youngest child's 18th birthday. All right, so I'm going to talk about this for 2 minutes. Situations where we have a taxable estate. Okay, so a situation where people are going to use trusts because they have enough money where trust can actually help them pay less taxes when they pass away. All right, so in Illinois, right now at least, and today's date is March 8th, 2023, for some context, the Illinois estate tax limit is $4 million. All right, and that's individual to my wife and I. We each get a $4 million coupon, if you will, when we pass away. What does that mean? That means that if we have, if I die first and my wife passed and we had a $5 million estate, right? And now my wife's got $5 million in her name. At her passing, there will be taxes due on $1 million because she's $1 million over the $4 million limit. And in Illinois, the estate tax is not portable, meaning I can't give my wife my $4 million coupon so that at her death, she can pass on $8 million tax-free. We're each given the $4 million coupon individually. So what that means is that if we have a joint trust, if we create one trust for the two of us, and at my death, we have a $5 million estate. And then at my wife's death, it's still $5 million. Again, there's going to be $1 million that's taxed before the money goes to our kids. And people always ask, is there inheritance tax in Illinois? It's not so much inheritance tax, there could be estate tax. And typically those taxes come out before the money goes to the beneficiaries. So the way that we plan for this so that we can avoid paying those estate taxes And again, this is as deep as I'm going to go here. We're not going to go into tons of detail. The way that we plan for this is that we would create two trusts. And we would have the Matt trust, and then we would have my wife's trust. Okay. And my trust would operate off my social security number, and my wife's trust would operate off her social security number. And we would still both be co-trustees of each trust. But what we would do is we'd have to divide up the estate. And right, if we had a $5 million estate, we'd put $2 million of assets in my trust. We'd put $3 million of assets in my wife's trust. Both of them are under $4 million. Upon my passing, my trust gets a tax ID number. My wife's still in charge of it. She's still the trustee. She can still manage the assets in it. She can still use the money in there for her benefit, for the benefit of our kids. But that money never gets added to her estate for tax purposes. Okay, so it stays separate. And upon her passing, all the money gets distributed to our kids. And because we're under $4 million on each side, there's no taxes. Okay, so again, I'm not going to go into any more detail on that, but this is why in some situations for a married couple, it might make sense to look at two trusts versus one. All right, anytime we're doing any estate planning, whether we're putting together just a will, right, which we talked about in the beginning, and in some cases, people just want a will. You know, they're like, yeah, I might go through probate, so be it, that's fine, great. So in some cases, we just put together a will. In some cases, we'll put together a joint trust for a married couple. Obviously, if it's a single individual, we might just put together one trust. If it's a married couple that has a sizable estate, we might look at two trusts. In any of these situations where we're doing a will-based plan or a trust-based plan, we are always going to be looking at including some other documents along with it, okay? We really look at planning and take a more holistic approach. So we look at powers of attorney for healthcare, property, a HIPAA, and a living will. So the healthcare power of attorney is a legal document where I'm naming somebody to make medical decisions for me in the event that I cannot make my own. I can name as many people as I want as my agent. Okay, the person that I'm naming to make decisions for me is called my agent. I can name as many people as I want, but I'm naming them one at a time. I cannot name two people together. Okay, Illinois does not allow that. Some other states do. I agree with Illinois that it doesn't make sense to name two people together. What if a serious medical decision has to be made and I've named two people, and even though they know what my wishes are, they're not agreeing? That would be a pretty difficult situation to be in, right? Situation I sure as heck wouldn't want them to be in on my behalf. So we can name as many people as we want. It's important to obviously name the right person. Okay, this shouldn't be like, oh, well, I've got 3 kids. I'm going to name, my kids one at a time in order of oldest to youngest. Maybe that makes the most sense based on their qualities and abilities, but maybe it doesn't. Maybe your youngest one would be the best one for medical decisions because he or she knows that you don't want your life artificially prolonged. And while it would be very hard to, not put the plug in or pull the proverbial plug, they know that's what you want, and they would do that. He or she would do that for you. Whereas that oldest child might have a really hard time doing that, or has told you that there's no way they could ever do that. Again, we need to talk to the people that we're going to name. Have conversations with them. I get it. It's not the most uplifting thing in the world. I'm not suggesting you do it like at Christmas or Hanukkah or any holiday you celebrate. That's probably not the best time to bring it up, but you have to talk to the people you're going to name. Make sure they're willing to step in on your behalf and make decisions that you would want them to make for you. Okay. So the healthcare power of attorney, we're naming people that can make medical decisions. The property power of attorney is who can step in and make decisions that are more financial in nature. And it's really who can step in to make decisions for me that are not healthcare related and not related to my trust. Because anything that's in my trust, real estate, checking accounts, brokerage accounts, if I'm incapacitated, my trustee is going to manage that stuff and will make decisions related to all of those assets. My property power of attorney will be dealing with things like my IRA or 401k. Remember, those don't go into my trust. They stay in my name, right? We might name the trust as a beneficiary, but those assets are going to stay in my name during my lifetime. So if I'm incapacitated, my property power of attorney will deal with my IRA or 401k. My property power of attorney will be the one that would file my tax returns with the IRS, deal with issues that might arise with Social Security or Medicare, or file a Medicaid application for me, or sign a contract on my behalf. And the contracts that we see power of attorney sign are, maybe somebody's older and they're hiring a caregiver, or they're moving into an assisted living facility or skilled nursing facility. These are all things that my property power of attorney would do. And again, we can name as many people as we want. It's one at a time in a specific order. The people that we name as property power of attorney tend to match up with the people that we name as trustees, which tends to match up with the people that we name as executors of that pour over will, or our will in general. And the idea really isn't, even though clients always say this, they'll be like, oh, my daughter's a financial advisor, she'd be the perfect trustee or power of attorney for property, or my son's a lawyer, he would be perfect for this. Yes and no. Do your son and daughter work 80-hour weeks because of what the types of jobs they have? Are they, able to kind of manage their own household, but barely? And so, if something happened to you, they might have a really hard time stepping in and managing, your life as well. So, I always tell clients, I'm like, just think of who's good at managing a household. Maybe it's your son, the stay-at-home dad. Maybe it's your niece or your nephew or whoever it might be. But again, let's think long and hard before we name people for these roles. It shouldn't just be based on how old they are or where they fall in the age group with the kids that we have. I tell clients all the time, people are always concerned about hurting their kids' feelings, and I totally get it. And I am not a mean-spirited person whatsoever. I'm a big teddy bear, believe me. And I tell them, I'm like, you have to be selfish. You can't be naming somebody first because you think that their feelings are going to get hurt if you name their other sibling first. You just can't do that. You've got to be selfish. You've got to think about yourself here, because these are very, very important matters. Okay. So the last two documents that we look at are the HIPAA and the living will. So the HIPAA is the healthcare authorization. All right. This is not who can make medical decisions. That's the healthcare power of attorney, which we just discussed. The HIPAA is who can have access to my medical information. Okay. And on the HIPAA, we can name as many people as we want, but there's no specific order. All right. Let me give you an idea of kind of how the HIPAA works. So on my HIPAA, I've got my wife, my parents, my siblings, my in-laws. There's 7 or 8 people on there. Any one of them can go to my doctor and ask for copies of my medical records if they want to. I don't think any of them would ever care to do that, but they could. And I have to be comfortable with the idea that they could. So really, the reason I like the HIPAA is that if there's an emergency and I get rushed to the hospital, any one of them can call the hospital, talk to the staff, go to the hospital, talk to the staff, talk to the nurses, and find out what's going on with me. Again, it's only access to information. It's no decision-making authority, and any one of them can, right? There's no specific order. The last document that we really make as a part of any estate plan we're creating is what we call the living will. The living will is the do not keep me alive unnecessarily document. This is not the same as a DNR. Some of you might be familiar with a DNR. It's now referred to as a POLST, POLST, Practitioner's Order for Life-Sustaining Treatment. It just goes, it's sort of like the DNR. It's just been kind of updated in the last 10 years, where it goes into a little more detail than just saying that you don't want to be resuscitated. Okay, there's a little more information on it. A DNR is a medical directive. Okay, it's a healthcare directive that is very controlling, if you will. Okay, so the example I always give is the paramedics come into my house and I have no pulse, I'm not breathing. All right, and my DNR happens to be laying next to me, or my pulse happens to be laying next to me. It says, do not resuscitate. Well, they're not going to resuscitate me. Okay, they'll leave me there. Now, in the same situation, but instead of the DNR, it's my living will. Okay, my living will isn't laying next to me. They're going to throw my living will aside and they're going to try to keep me alive. The living will does not say do not resuscitate. The living will is really just more direction to my healthcare power of attorney that I do not want my life artificially prolonged. Okay, it says do what you can to keep me comfortable, but at the end of the day, if I'm not going to have any kind of quality of life, don't just keep me alive to keep me alive. Now, what does this mean? Well, the living will is not appropriate for everybody. Just because we technically include it in all of our estate plans, we're obviously going to have some clients that are not going to sign it. They don't agree with it. We meet with people that do not want their, they do want their lives prolonged to the greatest extent possible, right? Keep me alive no matter what. Great, that's their decision. So they would not sign a living will, okay? But it's one of those, it's just a document that we offer as part of the planning, as part of the plans that we do for those that would like to sign it. That's really it. All right, I say that's it. Those are the documents that really make up a fairly traditional estate plan. Again, sort of what the will or the trust is like the main document that we're creating, and then all those other documents that kind of fall into place and make up the estate plan. So I hope you found this helpful. Obviously, there's still room for questions and some details that I probably left out, but again, this would be pretty much exactly what I would discuss if we were sitting down and either on a Zoom meeting together or if you were in my office. So obviously, if you have any questions, you can always shoot me an email or give me a call, and I look forward to talking to you. All right.